To the extent that I made that statement, that would not be correct according to this. Yes, sir.
And you talked about the photographic procedure that you directed the police to conduct on March 31st. Do you recall that?
Yes, sir.
And you said in your testimony that you didn't think that any of the Duke lacrosse players were suspects. Is that correct?
No, sir. I didn't say that I didn't think any of them were suspects. I said I didn't know who the suspects were. I said that we had a list of people that were supposedly at the house when this took place, and that other than that, I did not have a suspicion against any person.
So you had no suspicion against any of the people on the lacrosse team, the Caucasian?
No specific suspicion, no, sir. I couldn't look at one and say, I suspect this guy or this guy or this guy. They were all people who were members of the lacrosse team, were supposedly at the party, but I had no suspicion about any one of them specifically.
Now, to get a non-testimonial order, can you get that on anybody? Or do you have to have some basis to get a non-testimonial?
You have to have reasonable suspicion.
And you actually have to have reasonable cause to believe or suspect to believe that somebody actually committed a crime, correct?
Yes, sir, that someone committed a crime.
And if you look at Exhibit 203 in this case, the non-testimonial order that was entered in this case, do you see that?
Yes, sir.
And that was signed, prepared by the lead investigators on this case, but signed by David Saxon in your office.
Yes,
right?
sir.
And he's the chief assistant for you.
Yes, sir, he is.
And the very first page of that caption, under application for non-testimonial order, there's a parenthesis there that says adult suspect.
Yes, sir.
So this application from your office is identifying whoever's in this order as a suspect, correct?
Well, you could argue that, but if you look at page 3, it says name and description of subjects, not suspects, but subjects of the order. So
you're saying that this caption that says suspect doesn't really mean suspect?
Well, no, I think obviously that when you're asking for a non-testimonial order, it's because you think that it might give you information that helps you determine who's involved in the case, who's committed a particular crime. But as I indicated previously, I have never seen a non-testimonial order that listed 46 people on it. And the name and description is not of suspects, but of subjects. I think this is a very unusual non-testimonial proceeding.
Did you disagree with the order? Did you disagree with the application in the order that was obtained?
Well, it was already done by the time I did it. By the time I saw it, it had already been executed and served and all, but I don't know what you mean did I disagree with it. I think I previously testified that there was some language that I might not have included.
Well, you have to have reasonable grounds to suspect that somebody committed a crime to get this application, to get an order, don't you?
Yes, sir.
And are you saying that there wasn't reasonable grounds to suspect that these 46 lacrosse players committed this crime?
There was certainly not reasonable grounds to believe that 46 lacrosse players committed a crime. There were reasonable grounds to suspect that someone among those 46 lacrosse players could have committed a crime. But nobody ever suggested that 46 people committed a crime.
Did you disagree then with getting the order against all 46 people? Did you think that was inappropriate or ill-advised?
I thought it was unusual, but as I indicated, this was an accomplished fact by the time that I ever entered the case. I found out about the case by discovering a copy of this order.
And where did the photographs come from that were used during this photo identification procedure?
The one that took place on April the 4th?
Yes.
They were obtained from this non-testimonial order.
So you didn't necessarily agree with this, but you were willing to use the photographs that were obtained under it in the photograph procedure. Is that right?
Mr. Brocker, I don't know how to intelligently answer that question. I've tried to explain that the order is not the order perhaps that I would have drawn up in exactly the way I would have drawn it up, but it was a done deal by the time that I got into the case. So there was nothing that struck me about the order as improper, and had the order been felt to be improper by somebody, I'm sure there'd have been some kind of motion or for a hearing to have it disallowed, to suppress, or to, I think there's even provision for that.
But the photographic procedure wasn't done by the time you got involved, was it?
The procedure had not been done, no sir.
So if you disagreed with the order and didn't think these people were suspects, you didn't have any obligation to use the photographs that were obtained under it in the photograph procedure, did you?
Or for that matter, an obligation to use the buccal swabs for DNA testing, but we had the evidence and we were trying to find out what happened in the case, and so I used the evidence that I had.
Now, one of the positions that you've taken in this case with respect to the pretrial statements is that initially you didn't think they were improper because there were no suspects.
That was something that entered into my thinking as I was going through this. I mean, that if there are no suspects, then how can you be talking about something that's is going to prejudice a suspect if no suspects exist yet? Yes, sir. That was part of my thinking.
And in your initial response to the letter of notice and with respect to the pretrial statements, that was one of the grounds on which you said that none of the pretrial statements that you had made were violations of the rules.
That is correct.
And when you responded in the answer in this hearing commission, that was again asserted as the basis for why those statements didn't violate the rules of professional conduct.
Yes, sir, it was.
And in fact, even on the first day of your deposition, you testified that you didn't think that those violated the rules of professional conduct.
Yes, sir, I did.
Now, by April 4th, Ms. Mangum, well, let me ask you, under your definition of a suspect, at least by the time somebody's identified in procedure, photographically or some other way, they're a suspect, at least by then. Correct?
Yes, sir.
And on April 12th, you sought and obtained an order to seal the indictments against Reed Seligman and Collard Finnerty.
I don't recall the date, but that sounds right. I'm sure you have it there.
And so by that date, you had decided to seek an indictment against those two individuals.
Yes, sir.
Certainly they were suspects at that point, correct?
Yes, sir.
And you also have contended that your extrajudicial statements to the press, in this case, had nothing to do with your race for district attorney.
I was attempting to keep the case from becoming embroiled any more than it had to in the race for district attorney.
And at the candidates forum that we watched that you mentioned before, which of course was for the district attorney's race, you got up and said, "I'm not going to let Durham's view in the minds of the world be a bunch of lacrosse players from Duke raping a black girl." Correct?
Yes, sir, and I've conceded that was an improper statement.
And that was the day after you obtained indictments against these, or motion to seal the indictment against these two players.
Yes, sir.
Now, Mr. Witt asked you a question about the statement that Investigator Hyman testified about in this hearing, that he testified was at the initial briefing.
Yes, sir.
And making the comment there up on the board on the 27th.
Yes, sir.
And you were asked about that today, and you said that you believe that was made on March 30th, later that week.
I said I did not know exactly what date that it was made, that if I were asked to guess a date, that would be my best guess, but I don't know the specific date.
Do you have a specific recollection of making that statement?
Something similar to that. My recollection is that it was more, this is where or this is how we're effed.
Can you look at deposition again, please?
Yes, sir. What page?
page 49. The bottom of that, I asked you a question about that. I said, I'm going to have to use this language because it's exact. But do you remember making a comment in the meeting, and I'm talking about the initial briefing there, to the effect, in talking about this case and what happened up to this point, I think the exact quote was, "We're fucked." And your response was, "No, sir." You see that? And then you
Yes, sir, I see that.
And then you go on to talk about how you're not going to deny that you made the statement, but you have no recollection of making that statement.
And then I go on to say, but my recollection is that statement would have been made at a later time and in reference to some things that had been written by, had been put in a report